Frost still covered the ground when the bank's trucks rolled up her driveway. Standing in her barn doorway, coffee cup forgotten in her hand, she watched two men in county vehicles staple a seizure notice to her fence post, the same fence her grandfather had built by hand in 1962. Yes, this really happened. The bank really did seize her 1,200 acres. She really did warn them, in writing, that something was wrong with their numbers. And in that Iowa courtroom, the judge really did go completely silent for reasons nobody in that room expected. Comment below and tell me where you're watching this from. Ruth Ann Kowalski had farmed this land in eastern Iowa for 31 years, taking over from her father when arthritis finally forced him to stop working the fields himself. Corn and soybeans rotated across those 1,200 acres every season, the same rhythm her family had followed since the land was first homesteaded 3 generations back. She'd weathered droughts, flooded fields, and 2 brutal farm crises that had wiped out neighbors on either side of her property line. This bank dispute, she later said, felt different from the start. It began with an escrow account discrepancy, a routine part of her operating loan that covered property taxes and insurance payments each year. One autumn, a letter arrived claiming her escrow balance was thousands of dollars short, triggering a technical default on her loan agreement. Ruth Ann pulled her own bank statements immediately, certain there had to be a mistake. Her payments had gone through exactly as scheduled, every single month, for years. Calling the bank's regional office got her nowhere. A representative read from a script, insisting the shortage was accurate according to their system, and that resolving it would require an immediate lump sum payment she simply didn't have on hand during planting season. When Ruth Ann asked to see an itemized breakdown of the account, she was told that would take several weeks to process, an odd delay for numbers that should have existed in a database already. Refusing to wait quietly, she drove to the local branch with 3 years of her own canceled checks and bank statements in a manila folder. The branch manager, a man she recognized from her son's Little League games years earlier, wouldn't meet her eyes. He told her the discrepancy had come from corporate, not the local branch, and there was nothing he personally could do to change it. That night, sitting at her kitchen table, Ruth Ann spread out every financial document she'd kept since taking over the farm. Cross-referencing her own escrow payment history against the bank's claimed default notice, she found something that made her stomach drop. A payment she'd made in full had been recorded twice, as 2 separate partial payments in the bank's system, artificially creating a shortage that didn't actually exist. It wasn't fraud, necessarily. It looked, at first glance, like a clerical error buried inside a much larger loan servicing system. But when she called to report the specific discrepancy, hoping to finally get it corrected, the representative on the phone told her flatly that their records were final and not subject to dispute. Ruth Ann hung up, looked out at the frost settling over her fields, and understood this wasn't going to be resolved with a phone call. Determined to get someone to actually listen, Ruth Ann mailed a formal written notice to the bank's corporate office, laying out the duplicate payment error in careful detail, attaching copies of every relevant statement. State law required lenders to properly investigate disputed debt claims before proceeding with foreclosure, and she wanted a paper trail proving she'd raised the issue the right way, through the right channels, well before any seizure occurred. The response, when it finally came 6 weeks later, was a single paragraph confirming the foreclosure would proceed as scheduled. No explanation. No acknowledgement of her documentation. Just a date circled on a form letter, informing her she had 30 days before the bank would take possession of the property. Before we get to what happened when this reached a courtroom, hit subscribe, because the discovery that silenced an Iowa judge started with a filing cabinet most people would never have thought to check. With the clock now running, Ruth Ann found a rural legal aid attorney who specialized in agricultural foreclosure cases, a field that had unfortunately grown busier across the Midwest in recent years. The attorney, reviewing her documentation, confirmed what Ruth Ann already suspected: this looked like a genuine loan servicing error, not a legitimate default. And Iowa's foreclosure protections gave farmers specific rights to dispute exactly this kind of claim before losing their land. Filing a formal objection triggered a discovery process, forcing the bank to produce their complete internal loan servicing records, rather than just the summary notices they'd been sending Ruth Ann. The bank's legal team resisted, requesting extension after extension, claiming the volume of records made quick compliance difficult for a loan file spanning 3 decades. That resistance, Ruth Ann's attorney noted privately, was itself unusual. Loan servicing records for a single account typically weren't difficult to produce within a normal time frame, regardless of how long the loan had existed. The delay suggested either serious disorganization within the bank's records department or something else entirely that the bank preferred not to have examined too closely. When the records finally arrived, just days before the scheduled hearing, Ruth Ann's attorney spent an entire weekend cross-referencing years of transaction codes against her own statements. Buried deep in the file, in a section covering a system migration the bank had performed years earlier, he found something that went well beyond a simple duplicate payment error, something involving dozens of other loan accounts, not just Ruth Ann's, all affected by the exact same coding mistake during that migration. The Iowa courtroom filled quickly that morning. Word having spread locally that Ruth Ann's case had turned into something bigger than a single farmer's dispute. The bank sent 2 attorneys and a loan servicing supervisor, clearly expecting a routine foreclosure confirmation hearing rather than a serious challenge to their records. Ruth Ann's attorney opened by walking the judge through the duplicate payment discrepancy on her account, methodically laying out statements, transaction codes, and the bank's own internal documentation. The bank's lead attorney dismissed it as an isolated clerical error, unfortunate but immaterial to the broader validity of the foreclosure, and pushed for the court to proceed regardless. Then, Ruth Ann's attorney introduced what he'd found buried in the system migration records. He explained that the coding error affecting Ruth Ann's escrow account wasn't isolated at all. It stemmed from a botched software migration the bank had performed 3 years earlier, incorrectly duplicating certain payment entries across an entire batch of rural loan accounts processed during that specific system update. He'd cross-referenced Ruth Ann's account number against the migration batch codes and found the exact same duplication pattern affecting at least 40 other loan files, all originated through the same regional processing center. The bank's supervisor, called to respond, initially insisted this was impossible, that their systems had been thoroughly tested before the migration went live. Ruth Ann's attorney then produced the bank's own internal migration audit log, obtained through discovery, showing an unresolved error flag from that exact time period, one that had apparently been noted internally and never actually corrected. The judge, who had said very little throughout the morning, asked the supervisor directly whether the bank had ever gone back to verify that flagged error had been resolved across affected accounts. The supervisor hesitated, glanced toward the bank's attorneys, and admitted she didn't know that verification, as far as she was aware, had never actually been completed. That admission changed everything in the room. The judge set his pen down and sat in silence for nearly a full minute, staring at the migration audit log in front of him. When he finally spoke, his voice was measured but pointed. An unresolved, internally flagged system error, left uncorrected for 3 years, had potentially triggered wrongful foreclosure proceedings against dozens of Iowa farm families who had done nothing wrong except bank with the wrong institution during the wrong software update. He didn't just rule on Ruth Ann's case that day. He ordered an immediate halt to her foreclosure and demanded the bank produce a full accounting of every other account affected by that same migration error, under court supervision, within 30 days. Ruth Ann's 1,200 acres were hers again by the end of that week, the foreclosure formally vacated, and the disputed escrow shortage wiped from her loan record entirely. But the ruling reached far beyond her own farm. The court-ordered accounting the judge demanded uncovered 38 other Iowa farm accounts affected by the same uncorrected migration error, several of which were already deep into their own foreclosure proceedings, without knowing the true source of their supposed defaults. State banking regulators opened a formal review within weeks of the ruling, examining not just the technical error itself, but why an internally flagged problem had gone unresolved for 3 full years despite ongoing foreclosure actions tied directly to it. The bank issued a public statement acknowledging the system issue and committing to review all affected accounts. Though several farm families, emboldened by Ruth Ann's case, pursued their own legal claims for damages tied to foreclosure proceedings they'd already lost or nearly lost. Local agricultural advocacy groups began citing Ruth Ann's case in conversations with state lawmakers about strengthening farmer protections during loan servicing disputes, particularly around requiring lenders to fully investigate and document dispute resolutions before initiating foreclosure. Her name started appearing in State Farm Bureau newsletters, not as a cautionary tale, but as an example of what happened when a farmer refused to accept the records are final as an actual answer. Ruth Ann herself stayed remarkably grounded through the attention that followed. She planted corn that spring on the same fields her grandfather had cleared decades earlier, working the tractor past the fence post, where that seizure notice had once hung. She kept the manila folder of canceled checks in a drawer in her kitchen. A habit she said she'd never break again, regardless of how routine any future paperwork might seem. What stayed with people who followed her case wasn't just the legal victory, though that mattered plenty to the families who got their farms back because of it. It was the reminder that a duplicate transaction code, buried in a database update nobody outside the bank ever saw, had nearly cost dozens of Midwest families land some had worked for generations, and that it took one farmer's stubborn refusal to accept a dismissive phone call as the final word before anyone caught it. Her land is hers again, planted and growing exactly as it always had. And somewhere in a state regulator's office, 38 other farm files are being reviewed today because Ruth Ann Kowalski kept every canceled check she'd ever written. A duplicate payment code buried in a bank's database nearly cost dozens of Iowa families their land until one farmer's saved records exposed it. Her stubbornness saved far more than her own 1,200 acres. If this story moved you, subscribe for more real stories of ordinary people who refuse to back down.